Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? The European Union's Corporate Sustainability Reporting Directive mandates comprehensive sustainability reporting with an eye toward increased transparency for both EU companies and qualifying non-EU companies with significant operations in the EU. On this episode of We Get Work, we discuss the new reporting requirements as well as the additional due diligence exercise intended to identify risks on human rights and environmental issues, and also to mitigate those risks. We also consider how these obligations will be received in light of the recent shift in organizations' stance on ESG policies generally, which may make it challenging for U.S. employers to meet their obligations. Our hosts today are Laura Mitchell and Chris Anderson, principals respectively in the Jackson, Lewis, Denver, and Greenville offices. Laura co-leads the firm's ESG group, and Chris focuses his practice on cross-border employment work. They are joined by Peter Pevsnovsky, L&E Global EU Group co-leader and of counsel and knowledge manager at Van Olmen and Wijnen, a Belgium-based law firm. Laura, Chris, and Peter, the question on everyone's mind today is: what are the ESG obligations of U.S. employers under the CSRD, and how does that impact my business?
Thanks so much, Alicia. I'm Laura Mitchell. I'm a principal in our Denver office, and I also co-lead our ESG practice group. And I'm thrilled today to be joined with Chris Anderson, who is a principal in our Greenville office, a member of our ESG core team, and a member of the Jackson Lewis International practice group. And we are honored to be able to have the opportunity to speak to Peter Pevsnovsky from L&E Global, our international partnership. And we're going to be talking today about the intersection of ESG for U.S. employers and their obligations in the EU and what they should be thinking about, how they should be planning and preparing going forward into 2025 and beyond. And we're going to do something a little different today. I'm actually going to kick it over to Chris, and Chris is going to lead Peter and I in our discussion. So I actually get to answer questions today as opposed to asking them. So Chris, take it away.
Thanks, Laura. Yeah, as Laura said, I'm Chris Anderson, and I'm one of the principals with the International Employment Group here at Jackson Lewis. And for the last 10 plus years, I've been doing dedicated cross-border employment work and mobility work, and love to get to do what I do. But the shadow side of that, and it's not, I don't mean that in a negative way, but the reality is I work in over 100 countries, liaisoning with local counsel. So by nature, I have to be somewhat of a generalist in that, and hopefully go deep where I need to. But we cover a lot of countries in our work, and I do love that about it. But I do need specialists, and that's why getting to be with the brain trust today with Laura and with Peter is so important. And for every listener, you're going to get a treat of hearing from Peter Pevsnovsky, as Laura said, who is one of the heads of our EU Directives group within Labor and Employment Global, which is our global alliance in over 30 countries around the world and growing. And Peter runs the EU Directives group, is one of the leaders of that. And so, Peter, why don't you tell us a little bit about the EU Directives group and specifically the ESG directives that are coming down the pipe right now?
Thank you, Chris. Well, so as you said, I'm co-leading the EU group within L&E Global. We have a lot of different EU member states within the group, and so we come together virtually mostly, often to discuss the new directives, how can we help our clients with these directives and the case law of the Court of Justice of the European Union, and really all knowledge sharing, but also EU-wide projects to help the clients. Now, something that's really a trending topic within the EU are these ESG directives. You have two main directives, the CSRD and the CSDDD. CSRD is the Company Sustainability Reporting Directive. And this is all about transparency. It's about reporting on ESG matters. So it asks companies to make an annual report about ESG topics. While the CSDDD, it's the next step. It doesn't ask you to make a report, but it asks companies to make a due diligence exercise to identify risks on human rights and environmental issues, and also to mitigate these risks to take action. So that's the next step.
And Peter, let me jump in right there, just really quick, because the question on U.S. employers' mind and what we're going to really get to today in this discussion is really how does this affect U.S. employers, and what should U.S. employers be doing now to prepare and to begin to be compliant. So as we get to that, Laura, let's start with the U.S. though, and really where U.S. employers are obviously living first and foremost. What is the current state right now of ESG regulations in the U.S.? Kind of what are you seeing? What are you hearing? What do you hear from clients?
Yeah, that's a fantastic question, Chris, because the current state is unstable. For the past 12, 18 months, even before that, we've started to see shifting perspectives and priorities in the ESG space. Out of the George Floyd movement and the Me Too movement, we saw a push towards more transparency, more focus on ESG, not so much in the environmental space, sustainability, but from this social impact issues in the US. And we saw companies, organizations really getting pressure from stakeholders, employees, customers to be really forward about their stance on issues like diversity and employee protections. And in the most recent months, we have seen a turning of the tide, really the pendulum swinging to the other direction, where there is now competing interests that are forcing companies to pull back from their commitments to ESG standards, whether it be sustainability or the social impact issues or governance. So we see organizations trying to navigate these changing tides and try to figure out what to prioritize, what they're legally required and obligated to do, and overlay what they want to do as an organization. So there's no real clear path here in the US, and it seems as though we were kind of following the EU footsteps initially and really kind of getting some ESG laws on the books, or at least trying to, and some regulation. And now we have taken a bit of a turn, and we're seeing pull back from that, where it sounds like Peter's going to explain the EU is kind of still trudging forward with these new initiatives.
Yeah, that's because we'll transition to you, Peter, on this, because we want to hear differences or divergences from what Laura was just talking about. But just for a minute, I mean, imagine in a world where these were mutually exclusive, and the EU is doing what the EU is doing, and the US is doing what it's doing. No issue, right? No crossover implications would be needed there. We wouldn't have to discuss these things to this level, but that's not the case here. So Peter, for the U.S. companies out there, they're going to listen to this. How are they likely covered by these directives? You talked about the CSRD and the CSDDD. How are U.S. companies going to be implicated by these directives?
Thank you, Chris. That's a great question. The EU extended the scope of application of these two directives to a global scale. And so the directives can directly apply to US companies if they have a significant EU turnover, and if they have a physical presence within the EU. And by example, for the CSRD, it's around 150 million euros per year that they have to have a turnover within the EU, to give an example, and they need to have a branch within the EU. So then they will need to submit a report under the CSRD themselves. And so it's a direct application, while they can also be indirectly impacted. By example, if they have an EU subsidiary that is big enough to fall under the scope, the subsidiary will probably need them to give information. So they will have to go to their US parent companies to help them with these reports. Another way of indirect impact is that these directives also look at the value chain of companies. And so US companies, their clients or their suppliers might come to US companies with questions for their own reports. And of course, it's difficult to refuse information to clients. So that's another way how US companies might get involved.
Yeah, and I think that's such a big point, Peter, because it's not only going to be that direct implication, but that indirect. I think it's just key for U.S. companies to know about and be prepared for it, to be prepared that someone who is implicated that they're doing business with or affiliated with is going to be asking these questions to them. So there's even that implication as well. So as we go forward, Peter, call out a few of the requirements of the directives, like just a few that in the time allotment that we have today, that would be the most impacting for U.S. clients, U.S. companies to hear about.
Well, let me take as an example some of the social aspects of the CSRD, so the reporting directive. You need to report on 17 social aspects, a lot. We're not going to discuss all of them. But by example, one of the significant ones is the collective bargaining rate, the social dialogue systems within the companies. The directive asks you to report on how are you consulting employees? Are they covered by collective bargaining agreements? And as we know, of course, collective bargaining is a bit more significant and stronger within many European countries than in the United States. So that could be an issue, although also within the European Union, there are different levels of collective bargaining, of course. Another issue could be the fact that you need to report as a company on the social security and healthcare protection of your employees, and what are you doing to offer healthcare to your employees could be an issue. Also, by example, work-life balance. A third example, does the company offer paternity leave to employees or parental leave in total? All these things are examples that could be quite impactful for US companies. To give 3 examples.
Right. And this is really for all of us, for Laura and Peter, both of you guys together. Given, Laura, what you're saying about the shifting sand, this swinging pendulum here in the U.S., even some of the pushback against towards ESG in recent months, and that we anticipate will continue at least to some degree. And then what Peter's saying on the EU side, kind of where are those the points that Laura, that you think or could foresee U.S. clients really needing to dive in, dig in a little more on this to understand?
Yeah, I think, there's so many things to think about, but at a fundamental level, I think one of the first places I start is the definition of an employee. Because here in the US, it has been, whether you're an independent contractor or can be classified as an independent contractor versus an employee who is entitled to more protections and rights and benefits is a huge question. And that is just one piece of this puzzle that we have seen start to change over time, especially with the changes in administration. We've seen the pendulum kind of really swing both ways, and we're expecting it to come kind of back towards this notion that it's easier for employers to classify folks as independent contractors under the next administration, where it had been more difficult in the previous or the current administration. So I think how companies think about their workforce is going to be a starting point, because I think, Peter, I'll leave it to you to explain. The EU takes a little bit of a different perspective on employees versus independent contractors and the hurdles and the rigor with which you have to go to really be this independent worker.
That's correct, Laura. And it's interesting that you bring this up, because also on this topic, so if you use a lot of external workers or a lot of employees, you have to cover both of these categories of workers in the report. So you also really have to report on how you treating contractors, self-employed contractors, etc. So that's also an important issue that has risks, of course, because it could indicate bogus self-employment within the company. Now, self-employment or the qualification as employee is not regulated on EU-wide basis. It's only national law, except for platform work. There is a new directive. And so there is a lot of diversity within the EU on this topic. So it mostly depends on national law. But now we have this directive that forces at least the companies to report on that. So that's a new issue.
And that raises one big point for me, Peter and Laura both. It's that I think we don't know. We won't know until the answer is clearly we won't know until these directives really begin to be transposed by the member nations across the EU. We'll see this flesh out, and we won't fully know the effect till then. But U.S. companies need to be preparing now and thinking through it now, because my big question, Peter, and to you and Laura both, is how likely do we think it is that the responses to either one of the directives, so the diligence and the reporting, that could lead to or trigger labor audits or tax audits? Is there, Peter, have you dealt with that at all? Is that something that you even think could be a potential trigger here? And we're talking about contractors versus employees. When you report on these things, could that trigger an audit in somewhere in the EU in a member nation?
Well, the interesting of these reports is that they will have to be published online, accessible for anyone. So not only the social inspection services will have access to them, also trade unions, which are often quite powerful within the EU. And so I think definitely they will trigger social audits by social inspections, and they will also probably use it against employers if they come with different information in a private investigation, by example. That will be a major risk. So you really have to think, what are we reporting, and can we uphold this later if we have to give more information towards the social audit? So yeah, I think so.
Right. And I do think, practically speaking, I've actually seen this flesh out already in a different context with government contracting, where there's diligence that contractors have to do to downstream providers, and then they find out the provider has tons of contractors around the world, and it becomes a lightning rod issue of having to think through, okay, what are we exposed here? I think this is going to be even more potential for that as well. And one issue that I've had, practically speaking, is in the union context that you just mentioned, Peter, was where there was a union complaint brought against a car manufacturer just recently, based on the German law. This is a predecessor to these directives, and it's kind of walking in step with them, and basically saying that the U.S. actions towards collective bargaining in the U.S. were violating the German statute. And so again, how this will flesh out in terms of how these laws will be transposed and what effect they have on U.S. clients and companies, I think is to be continued. But I want to believe that, Peter, and maybe you can opine on this as we come to a close, I want to believe that as long as U.S. companies can show that they're following in lockstep as closely as possible with U.S. law, that they will be able to give the diligence on that, to report on that, and that will be sufficient through this. I know we won't exactly know how this will flesh out, but what's your take on that, Peter?
Well, Chris, I think that the directives and the reporting standards included in the directives are really drafted on a European view, on a European basis. And so indeed, these ideas about social rights are really from a European perspective, where, by example, the right to collective bargaining is extremely important. And so it could be indeed used by European workers or trade unions against companies in the US. However, I tend to agree with you. If you can show as a company we are actually following local rules and local laws and fundamental rights that are applicable within the US, then probably there will not be an issue. But of course, this is the US, a trusted partner of the EU. Look at other countries where the laws are maybe less democratic, where there are maybe forced labor camps. Then, of course, the argument that we are following local law will not apply. So it's a tricky issue, let's say. It will really depend on the situation. But for US companies,
Right.
I do not assume that this will be a major issue to use this argument. Yeah.
Right. Yeah. In a baseline, it will, at the very minimum, there'll be, however the legalities shake out, and we know for sure there'll be pressure exerted on U.S. companies to come into compliance with a European sensibility, or to kind of come to that level. This union complaint that I reviewed, it was clearly trying to overlay that, so put that pressure on a U.S. company, and really on the German parent to put pressure on the U.S. company to toe that line. And so, I guess it remains to be seen. Laura, what are your closing thoughts on that in terms of blending these together?
Yeah, I think the overarching thought for me is one aspect that we haven't talked about from the US perspective is this notion of company reputation, and the fact that a lot of pressure in the US on organizations have come not from legal enforcement, from regulators, or from the court system, but through activist shareholders, through this cancel culture that we have from customers, from employee attrition who are kind of speaking with their feet. And we had this great migration of employees who left organizations because they didn't align with their values. And so I think part of this that companies have to think about is, what are their values as an organization, and how do they align with the compliance requirements in the EU and what they're being asked to do in the US? And can they take one singular position, or are they comfortable kind of having divergent or differing positions depending on the jurisdiction? And maybe that's a question that gets answered by another question of who's exerting the pressure, who's asking the action of the organization, which stakeholder are we needing to respond to? So just kind of some parting thoughts as we kind of round out our discussion today. Certainly not the last time that we'll be talking about these things. And I'm actually excited to talk to you guys again next year in 2025 to see what developments we have and where we go from here. So I really appreciate the dialogue. And Peter, thank you so much for your expertise and for joining us. And we look forward to the next time we get to chat.
Thank you, Laura. The pleasure is all mine.
Yep.
Yeah, thanks both.
Thanks.
Thank you for joining us on We Get Work. Please tune in to our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.